Section 13, Implied Agency Do's and Don'ts of Agency. Introduction, the agency relationship you never meant to create. In the previous section, we discussed buyer representation and the importance of discussing agency before providing client-level services. We learned that one of the biggest mistakes agents make is continuing to provide advice, guidance, property showings, and negotiation assistance without first explaining how they represent the client. This naturally leads us to one of the most misunderstood concepts in agency law, implied agency. Implied agency is dangerous because it often develops without anyone realizing it. The buyer believes the agent represents them. The agent believes they are simply being helpful. The broker assumes the proper forms were completed. Then, when a problem arises, everyone discovers they had a different understanding of the relationship. Many agency disputes begin with a client saying, "I thought you were my agent." What is implied agency? Implied agency occurs when an agency relationship is created through conduct, actions, behavior, or circumstances rather than through a formal written agreement. In other words, the relationship is implied by what the parties do instead of what they sign. Unlike an express agency relationship where the parties sign documents clearly establishing representation, implied agency develops because a reasonable person believes representation exists based on the agent's actions. This is why agency discussions should occur early. If an agent begins providing services that appear to be representation, a client may reasonably assume the agent is acting on their behalf. How implied agency happens in real life. Imagine a buyer visits one of your open houses. They ask questions about the market, financing options, neighborhoods, and comparable sales. You answer their questions and offer to show them additional properties. Over the next several weeks, you spend your weekends showing homes, discussing offer strategies, recommending inspectors, reviewing disclosures, and helping them evaluate properties. The buyers begin relying on your advice and expertise. Yet throughout this entire process, you never discuss agency, never provide a read form, and never establish a buyer-broker agreement. What has happened? From the buyer's perspective, you are their agent. From your perspective, perhaps you are simply helping. This disconnect creates implied agency. The course material explains that when agents provide client-level services without discussing agency, they may unintentionally create an agency relationship through their conduct. The internet has increased the risk. Today's real estate market creates agency relationships differently than it did 20 years ago. Many buyers first meet agents online. They submit inquiries through websites, send emails, respond to social media advertisements, or request information through listing portals. The course material provides an example of an out-of-state buyer who contacts an Arizona agent through email, requests information about properties, schedules a weekend of showings, and relies on the agent to assist with their home search. Even though the parties have never met in person, the buyer may already be seeking client-level services. The important lesson is that technology does not eliminate agency responsibilities. Whether communication occurs in person, by telephone, through email, or electronically, the obligation to discuss agency remains the same. Rules updated. Electronic communication does not change agency duties. Many agents mistakenly believe that electronic communication somehow changes agency obligations. The course material reminds licensees that sending documents through email, electronic signature platforms, websites, text messages, or other digital systems does not reduce the obligation to explain agency relationships or ensure clients understand the forms they are signing. If an agent would explain a form while sitting across the table from a client, the agent should provide the same explanation when the documents are delivered electronically. Agency disclosure is about understanding, not simply obtaining signatures. The Realtor Code of Ethics and Agency Relationships. The Realtor Code of Ethics recognizes that agency relationships can be established through both traditional and electronic communications. Article 1, Standard of Practice 1-2, explains that realtors have ethical duties regardless of whether activities occur in person, electronically, or through any other means. The standard also distinguishes between prospects, customers, and clients. This distinction is important because not everyone who contacts a real estate agent becomes a client. A prospect becomes a client when representation begins. The challenge for licensees is recognizing when that transition occurs and ensuring the appropriate agency discussions take place. When does a seller become a client? Seller agency is often easier to identify than buyer agency. Most sellers become clients when they ask a licensee to market and sell their property. At that point, the agency discussion should occur, and the agency disclosure form should be completed. The seller generally has two agency options. The broker may represent the seller exclusively, or the seller may authorize limited dual representation if a buyer is later represented by the same brokerage. The important point is that the agency discussion should happen at the beginning of the relationship, not after an offer arrives. The legal problems created by poor agency disclosure. Many agents believe that failure to complete an agency disclosure form is what creates liability. In reality, agency disclosure issues often become important only after something else goes wrong. Perhaps there is a property defect that was not disclosed. Maybe a boundary dispute arises. Perhaps a financing issue develops, or a transaction falls apart. When attorneys review the file, one of the first things they examine is the agency documentation. The course material explains that when agency forms are missing, inconsistent, or contradictory, attorneys often add claims involving representation issues. This is why proper agency disclosure is not just a compliance exercise. It is one of the best risk management tools available to a licensee. Arizona law expects licensees to promote and protect the interests of their clients. Under ARS Section 32-2153, the commissioner may discipline a licensee who fails to promote and protect the interests of a client. When agency relationships are unclear, it becomes much more difficult to demonstrate that those duties were fulfilled. A client who does not understand who represented them is far more likely to become dissatisfied if a problem develops later in the transaction. Good agency disclosure protects everyone involved. Consistency matters. One of the most common agency mistakes occurs when the agency disclosure form says one thing and the purchase contract says something else. The course material discusses situations where agents properly explain agency, but later incorrectly identify representation on the Arizona residential real estate purchase contract. Consistency is critical. The agency disclosure form should match the representation indicated in the contract. The contract should match the broker's file. The broker's file should match the actual relationship that existed. When everything aligns, agency becomes much easier to defend and explain. Agency flows from the broker. One final concept is critical to understanding agency in Arizona. Agency flows from the designated broker, not the individual salesperson. Many agents think of agency as something they personally create. However, Arizona law views agency through the brokerage relationship. If one agent in the brokerage lists a property and another agent within the same brokerage sells that property, the brokerage has created a dual agency situation because the designated broker ultimately represents both parties. Understanding this concept helps agents recognize agency situations before problems develop. The big lesson: implied agency rarely occurs because an agent intentionally creates it. It usually occurs because an agent starts helping before discussing representation. The solution is simple: discuss agency early. Explain the available relationships. Answer the client's questions. Document the election. Make sure your actions match the representation selected. When agents consistently follow these steps, implied agency becomes much less likely, and clients gain a much clearer understanding of who is protecting their interests throughout the transaction. Online discussion questions. Question 1. Why is implied agency dangerous for a real estate licensee? Answer. Implied agency is dangerous because the client may believe representation exists, even though the relationship was never properly discussed or documented, creating confusion and potential liability. Question 2. How can electronic communication create implied agency? Answer. Buyers may begin relying on an agent's advice, guidance, and services through email, websites, text messages, or social media before agency is formally discussed, creating the appearance of representation. Question 3. Why is consistency important in agency disclosure? Answer. Agency forms, contracts, broker records, and the agent's actions should all match. Inconsistencies may create confusion and increase legal risk if a dispute develops.